My name is Prosper Maguchu, and today I want to take an opportunity to discuss a little known statute that was passed by the United States Congress in 1855. Yes, believe me, I say 1855. More than 150 years ago, the United States Congress passed a law to help litigants in other countries to obtain evidence from the United States. To put it differently, a litigant in any part of the world, be it Indonesia, an African country, or Latin America, anywhere else in the world, can approach a judge in the United States for evidence. This could be oral evidence, this can be documents which they believe can be useful in an ongoing domestic litigation. I also want to talk about using this statute 1782 in money laundering. And I want to briefly make a diversion and talk about a method that is often used by investigators in money laundering cases. This is a method that is called following the money. So, metaphorically speaking, whenever money exchanged hands, be it virtually or in person, it leaves some footsteps, especially so if it's done via banks. And there's also another important thing that I want to add that is maybe not common to most of our viewers, that usually, and partly because of globalization, these days most international transactions are done in US dollars. So this is called dollarization or partial dollarization. So if a buyer in Indonesia, for example, want to make a transaction or buy goods or services from another country, that transaction is usually done in US dollars. And for those processes that are handled in US dollars, the clearance of that transaction has to be done by a US-based bank. And most of these banks are based in the United States. And actually, most of them are based in one state, in New York, in one area in Manhattan. That's where most of these banks are based. So, which means they all fall under the jurisdiction of the American courts. So, what one can do is that when investigating money laundering cases, and they believe that money was transferred from one bank to another, it can be in Indonesia itself, between Indonesian banks, or between a bank in Indonesia and a bank in Singapore, or a bank in a well-known tax haven, where you believe that transaction might have been suspicious and he has escaped, the bank authorities. They did not investigate, pick it up, but you believe it is suspicious and you want evidence to prove that money was acquired illicitly or is being used for illicit purpose. Then one can approach an American court to request for evidence or information from a related or an involved clearing bank. So, what are the processes of getting this statute 1782? The processes of getting statute 1782 are quite clear and straightforward. First, one needs to show that the court in the United States has jurisdiction, and usually just the physical location, either of a financial institution in the United States or the person who has evidence that you need to use in your case is based in the United States. Their physical location or physical presence in the United States suffices. So if you can just prove that the bank is in the United States or the person with evidence is in the United States, then you can easily approach an American court for subpoena 1782. Secondly, you also need to show that that information is very key to an ongoing litigation. Of course, American courts has interpreted this provision differently. Others believe that certain procedures may not count as litigation, but the majority of courts in America, they can assist or grant, are easy to grant statute 1782 if you can simply show that you are going to use it in an intended legal investigation or court case. And the third aspect, you also need to show the court that this information is very key. It may lead to a successful conviction of money laundering, for example. And in this case, the litigant or the person applying for Statute 1782 doesn't have to do anything. The onus is on the person who is opposing the granting of Statute 1782 to show otherwise, to show that even if we give this information, it is of no value. So all these are the simple steps that are required if one has to apply for Statute 1782. Now, allow me to share with you two examples where Statute 1782 was used in money laundering cases. And these two examples are, to the best of my knowledge, the only cases where Statute 1782 has been used in following the money. As I said, follow the money to secure a conviction. The first one involved a well-known Russian case of Sergei Magnitsky. So those people who were working with the family of Sergei Magnitsky to get justice for the late tax lawyer Sergei Magnitsky, who was executed, extrajudicially killed in Russian prison for exposing corruption, they approached Swiss courts, the courts in Switzerland, to confiscate proceeds of corruption that was believed to have been stolen by the killers of Sergei Magnitsky, and to obtain evidence that would help them to show the transactions, how money was transferred from Russian banks to buy properties in Dubai. They knew that some American banks were involved, so they used Subpoena 1782 to compel American banks to give them evidence that was successfully used in this case to show and prove that the killers of Magnitsky had indeed embezzled more than $250 million, for their personal or private use. And more recently, in an ongoing case in Nigeria, lawyers representing the government of Nigeria and the Attorney General of Nigeria, they have successfully persuaded a United States judge to grant them subpoena 1782 against unnamed American banks, because they believe that the evidence they are going to use in this case will help them to prove corruption by certain Nigerian government officials. I will close by saying that Section 1782 is the most cheapest, efficient, and fastest way one can use to secure evidence in cases of financial investigations. And it is very key for Indonesian officials, but not only Indonesian officials, also those who are involved in fighting crime, be it in civil society, private consultants firms, or those who are clients of those involved in this, in the area that I've just mentioned, to familiarize themselves with this little known, very important, powerful provision that could be the missing puzzle in reducing financial crimes. Thank you.